the lottery commission make these racetracks agents, the lottery commission to carry out the, are they different than these lottery agents we have at convenience stores and everywhere else?
Absolutely. If you look at the proposed rules, it's interesting. First of all, those point agents are split 50-50. Second of all, if you look at the proposed rules, there's an interesting provision. The Lottery Commission is going to require the 7 tracks to submit their business plans and security plans to the Lottery Commission. I will tell you that Joe's Deli isn't required to send his business plan to the Lottery Commission to sell lottery machines, and I doubt that the Lottery Commission is approving his security plan. This is, you know, the facade that this is some sort of regulatory relationship between the Lottery Commission and the racetracks will crumble because it's a facade made of clay. This is a joint venture. The state of Ohio deliberately made a decision through the governor's office and the lottery to lease the machines instead of having the tracks lease the machines, so they could try to argue that this still falls under some sort of regulatory framework. But we rolled through discovery, and thank you for section 3770.21, because I can take discovery, even though the case is in the Supreme Court, which would have been a bigger problem because this was just a writ case. But thanks to that jurisdictional provision, through discovery, we are very comfortable. We will show that the facade, that this is merely a regulatory arrangement, is just that, a facade. It will crumble, and that what's here is really a joint venture where the state of Ohio will provide the machines, the private tracks will provide the location, the state of Ohio will review their business plans and their security plans, have on-site people involved in the overseeing of this thing, and split the profits on basically a 50-50 basis. That's certainly not what's going on with Joe's Deli and his lottery machine.
You said the General Assembly is not a defendant in this lawsuit, but will your litigation get to the legislative changes made in the budget, specifically the change in the definition of a lottery?
That issue is raised in the roundtable suit. It's not raised as a cause of action.
Why not?
Because it's already raised in the roundtable suit. No reason not. Need that issue closed.
Maybe Mr. Long, there's been lots of speculation about who's paying for what in the various lawsuits. Are you receiving any money from gambling interests to support this, or how are your effort being financed?
That's a great question. The answer to that is absolutely no. And we, obviously in Ohio right now with issue 3 on the ballot in November, and of course what has happened with this whole lobbying effort to get the slots at the racetracks, has been a lot of casino and gaming money from states all around Ohio that every election it seems like they're either for or against. And we as family groups, obviously, we have to, from our own meager resources, have to mount a challenge. And we are appreciative of those who are volunteering their time in this effort, but we believe that we have expert counsel, and our case is very strong before the Supreme Court.
I might add to that, because I am a pro bono attorney in this. I'm not receiving any money, anybody, Christian Alliance, these 3 fine state representatives, or any outside interest. I've talked to no outside interest or gambling interest. This is a constitutional quest for me. I think that the Constitution, which is the supreme law of the state of Ohio, and the people's law, deserves to have this opportunity to litigate these issues. And so everything has been prepared to date around my time, my nickel, or the copies on his nickel, and the filing fee on his nickel. But I will take another dime for this. It's totally
so your organization is financing it, not
correct.
Senator, why do you not believe that it's a single subject issue?
I raised a single subject rule here. I raised a 3-day rule here. But the question was asked back there was the question of the expansion of the governor's power under the lottery. That issue was raised in the roundtable case. We did not include it in this case.
So, but why isn't it a single subject? Why? I mean, you're talking about a lottery that would raise $900 million for the budget. Isn't it? Would most people look at that and say, well, that's budget related?
Well, that's a good question, because if you read our pleadings, you'll notice a very good legal nuance. If House Bill 1 would have expanded the lottery to include slot machines per the normal language, you might have the argument it's a single subject. But as you may recall, House Bill 1 didn't do that. The governor's directive, which is attached to the complaint, expanded the lottery. So it's not an appropriations issue, because the appropriation action was done in the governor's directive, not in House Bill 1. Therefore, that is one of the additional arguments why this is a single subject violation. You have a regulatory and criminal law change at the last second, perhaps to accommodate the governor's directive, but it was the directive that expanded the appropriation, which is what that roundtable said was wrong to begin with. We do agree, we just didn't raise it. So it doesn't violate the single subject rule. I will say this though, our 8th cause of action that does dovetail with theirs is that the governor in that effort took over $900 million of GRF funding that was going to the education foundation aid and took it out and is trying to replace it with over $900 million purportedly to come from the VLTs. And that also violates the state constitution because all the money from the VLTs, if it is constitutional, has to go to education. So that's an additional claim that we did raise in the complaint. I mean, this thing is just got constitutional defects on many levels.
Could all of these arguments have worked against Keno the last time around if you chose to challenge it?
Could all these arguments work against Keno? I don't know. I haven't studied it.
I mean, wasn't it essentially done the same way, even though it was not?
I don't think you get the 50-50 split. I don't think you get the business plan approval. I don't think you have the depth of the state's involvement in the process. I mean, ask yourself a question. If the state wanted to allow slot machines, why is the state paying for them? I mean, why isn't the private operators of the machines paying for them? If this was truly a regulatory act, you know, we didn't buy the tracks and then lend them to the owners. We don't buy the horses and lend them to the owners and take a 50-50 split. I mean, in this situation, the state is complicit in the process through the governor's directive by actually purchasing the devices themselves and providing them, and then taking a 50-50 split. I think you'll find out that that was not done by accident. I think that was done in part to try to get this under the guise of a lottery. But that's going to be the issue for the roundtable.
I said at the time that the action on the Keno initiative was going forward through the legislature, that it was the open, the camel's nose under the tent that could be a precursor to further expansion. Just as what we're standing up against today may not be the final outcome of what the state could do if this is allowed to stand as well. So yeah, it wasn't challenged legally, so we don't know what would have happened. But I agree with the senator that the basis is more egregious and a longer list of problems here.
Well, and just to dovetail one thing Representative Amstutz said before, I will challenge the media to go out and ask 10 people who were alive in the 1970s when we voted for the lottery and ask them, did you think you were authorizing slot machines? And if you can find 3 who said, yes, I voted to authorize slot machines, well, I said, let's have a lottery, I'd like to read